Younger. I need Mr. Younger to turn on his camera. Anybody who's going to participate in this hearing, I need to have their camera on, please. While that is happening, thank you. Mr. Younger, do you not have a camera that works?
No, I do. I apologize. I'm trying to figure out the Zoom here, man, Your Honor.
Usually down at the bottom left of your screen, there's a little video icon.
Thank you. I see that now. Oops,
It's still not working.
still not working, huh? I can see it when I click it. It doesn't bring me up. Huh.
Let me give some preliminary announcements. It's before lunch, so I'm not sure how far we're going to get on this before lunch. We're holding today's hearing remotely via the Zoom platform because apparently everybody agreed to do so, which is fine. All the rules of decorum apply to the Zoom platform just as if we were in the actual courtroom, except that you don't have to stand when you address the court when we're on Zoom. No, just as if we were in the actual courtroom, no one who is on the Zoom platform, nor anyone who might be watching the court's YouTube channel, which we're live streaming this hearing in order to comply with the open courts provision. No one who is here in Zoom, nor anyone who is watching on the court's YouTube channel is permitted to make any recordings whatsoever of today's hearing, exactly the same as if we were in the actual courtroom. Anyone who does make a recording of these proceedings in violation of this admonition is subject to a finding of contempt of court. Does everyone understand my instructions?
Yes, Your Honor.
Yes, Your Honor.
Okay. We're going to have to get Mr. Younger's camera figured out because I can't have a hearing with him unless I can see him. But
Mr. Younger, do you see the bottom of your screen where there's a red line over video in the bottom left?
It does not have a red line. It just shows the video. When I click on it, it does put the red line on it. But it's like right now I just put the red line on it. Now it's gone, so I should be coming up.
Okay, can you go to your Zoom settings and make
Okay.
sure your video, that box is checked?
Help me find my Zoom settings here.
Yes.
Share maybe?
no.
Would that no?
Click on the camera icon, the video icon, and if you click on the up arrow, you'll get
Okay.
a list of things to select.
So what I'm seeing is HP True Vision, HD camera is checked, and then it says blur my background, adjust background and effects in the video settings. So
Is it possible he might have like a something hiding his camera at the top of his computer? Like there's a privacy on some computers at the top.
Yes, it
Like
could
it's a little plastic privacy thing that you can click back and forth. I don't know if that's just an idea.
okay.
Are you on an actual computer?
I am. Yeah, it's a HP. It's my first time. It's a new computer I just bought.
I'm not the most tech savvy, but you need to go to your computer settings then.
Okay.
That could be something.
Let me go ahead.
While he's working on that, I need everyone to give me appearances, please.
Good morning, Your Honor. Colleen Kinsler here on behalf of Alicia Younger. Miss Younger's original attorney was Ariel Rosval, and she is out on maternity leave beginning this week. So I am stepping in and helping out Miss Younger going forward.
Who else do I have, please?
Good morning, Your Honor. Janie Clements on behalf of Siberian Younger. I also am stepping in and new to this case as of the last few weeks. A previous attorney from our firm no longer works here, Raven Brown.
And who's Mr. Williams?
This is my associate, Jared Williams. He's just here to observe, if that's all right.
Yeah, that's fine.
And Sarah Martin is a paralegal on this case with my firm, Your Honor.
I recognize Ms. Martin. Hi, Ms. Martin. All right. So let me tell you what I have set. My docket shows that we have, Ms. Younger's motion for temporary orders, Ms. Younger's motion to compel, Ms. Younger's motion to enforce, and I have a motion to withdraw filed by Mr. Connolly.
That motion to withdraw, we're withdrawing that motion.
Okay,
That
we're
is
not
been
we're
resolved.
on that. All right. What is your updated time announcement?
Your Honor, I still believe we need 3 hours. I'm hoping to give some time back, but it really, I think it would depend on how quickly we can get through the compel and the enforcement, as those are kind of clunky motions anyway.
Okay. Maybe the compel is attorney argument, but I'm not going to proceed unless Mr. Younger can get on a computer that we can see him. Miss Clements, is Mr. Younger in your office?
He's at home, but my associate Jared is calling him right now to walk through and try and get this worked out.
Okay.
I apologize about this, Judge.
Yeah, that's all right. Mr. Younger, I don't think, yeah, turn off your volume while you talk to Mr. Williams. While he's doing that, we can go until a little afternoon. I have somebody coming back at Ms. Chambers, help me. I think it's 1 o'clock. I need to look at my calendar, or 1:30 for about an hour. So,
Yes, ma'am, it's 1 o'clock.
okay. So I'm not going to go too much afternoon because we have to have a lunch break. But so we'll do what we can for the next few minutes, and then we'll come back at 2. All right. I think we could take up, in the interest of time, I think we could take up the motion to compel while Mr. Younger's working on his technology issue. And then if we can't figure it out, I'm going to ask Mr. Younger to go down to Ms. Clements' office and get on a computer where I can see him, or we're going to have to reset because I'm not going to have a temporary orders hearing where I can't see the respondent. All right. So, Ms. Kinsler, do you want to start with the motion to compel?
Yes, Your Honor. Did you want me to share screen with the motion to compel document, or how would you like me to proceed?
I have it pulled up if it's helpful to everybody else, but otherwise I have it pulled up.
And just for some background, we sent discovery on December 6th. On January 13th, Mr. Younger responded without providing very many documents. And in his discovery responses, for every single document, if you look at page around 36 or 35 of the motion to compel, Your Honor, it's one of the attachments, you'll see Mr. Younger's objections and responses and requests for documents. And why this is important. And I am gonna share screen. For every response, Mr. Younger didn't raise objections, but instead said, due to accessibility issues involving Mr. Younger's personal computer, cell phone, and his primary marital residence, he's not been able to gather documents. And then please see documents produced in inventory and exchange. As we sit here today, it has not been updated, meaning that there have been supplemental documents provided, but this document still remains as is, right? So the supplemental documents the responses have not been updated. So I do not know, when the responses have been provided, what all requests for productions that they're applicable to. Some of them, when they have been produced in folders. However, that's not for all of them.
All right. Ms. Clements, is Ms. Kinsler supposed to guess which RFP the documents are responsive to?
No, Judge, every document we've supplemented that corresponds with a request has been in a folder that says RFP 1, 2, and so on. There's been additional documents in response to the enforcement on file that don't pertain to a request that we have sent over. Those, I believe, are the only documents that have not said specifically which request that it corresponds to. And I would just also like to add, there have been some difficulties with getting documents because when this case started or when the parties separated in November, an EPO was granted. Mr. Younger was kicked out of the house. He was given about 45 minutes to gather his belongings. His phone and computer were left at the house. He did not receive those back and held by the opposing party at opposing counsel's office until a temporary orders hearing. I think it was on January 4th. And then Judge Arth ordered that there would be a forensic phone dump done on both the phone and computer of Mr. Younger. And he did not receive his phone or computer back until January 13th. So since then, we have been working to supplement as best as we could, but there was an issue in that time period when the discovery responses were initially due, which is why that is in those responses of he just doesn't have those documents available to him at the time. He did not have a computer. He did not have a phone. And also a lot of these documents, as we go through each one, I can point out to the court that our client is saying those are actually in his desk drawer at the marital residence, which he hasn't had access to since November.
All right, but you haven't revised your written responses to say things like, I don't have access to them because they're in the marital residence. Or you haven't revised your written responses to say, to RFP number 1, see, attached documents or documents provided in folder, right?
No, that's correct. We have just sent that's in each production link has said RFP 1, and we've dropped the specific documents within that response.
Well, you need to revise your written responses.
Okay, we'll do that.
That's the first order. So you're ordered to revise your written responses to say what you've responded to and what you haven't. Now, do we need to go one by one for the requested documents, Ms. Kinsler?
I believe we do. And we had prepared a proposed order that I actually sent over to Ms. Clemens just before the hearing of what we were still missing. And so I prepared a proposed order. And so I can just go through.
Yeah, we lost Mr. Younger. Do we need to wait for him to come back?
Yes, Judge, he is exiting and trying to come back in. I've been walking him through his video settings.
Let's see if we can get him back in.
Yes, but
There he is, but I still see that he didn't have his camera on. But Ms. Clemens, have you reviewed the proposed order?
I have. We received it about 30 minutes ago, so I've done my best to go through it.
Would it be helpful for you to go through it with your client if you had an opportunity to do that?
I went through, I think we're good to move forward. I mean, I went through the motion to compel with him, and Ms. Kinsler's office was very detailed on what they were specifically asking for.
Okay.
So, and Your Honor, we'll start going through the documents or my order to compel. But I did want to bring up one of the things that Ms. Clemens brought up, which was the R3 forensics. Those items were ordered to both the laptop and personal laptop and cell phone were ordered to be turned over to R3. R3 was able to download Mr. Younger's cell phone. However, his laptop was set to lost mode. So as soon as it was opened to try to start downloading, it reset to factory settings and deleted everything. Mr. Younger has previously represented that he set it to lost stolen mode because the laptop was stolen. However, as you just heard his counsel testify, he knew that it was left at the house and it was being turned over, or that we were requesting it be turned over to R3, and that we had not accessed it or touched it until we had the court's permission to do so. However, all of the laptop, like I said, it was set to lost. So as soon as it was accessed, that has been completely wiped now.
Did you all know it was, hold on, did you all know it was set, it had that setting before R3 did it? So
No, Your Honor.
so nobody talked to him about it, so that
I do not know what conversations Mr. Younger had of why he proceeded to set the laptop to a lost or stolen mode, considering he knew that the laptop was at the house, he knew Miss Younger had it, he knew that we were wanting to turn it over to forensics. And so at this point in time, because R3 knew that the laptop was wiped when they tried to access it, for the cell phone, they actually had Mr. Younger come down and put his face on the phone so that it couldn't be wiped upon opening it. So we do have information from R3 Forensics that we have not looked at yet. They are requesting a court order that says that we can have access to all of the downloaded information from Mr. Younger's cell phone. We were supposed to be able to have access to the cell phone and the laptop, but now we are just left with a cell phone. My understanding of what R3 has found and is wanting to provide is similar to a iTunes update or an iTunes cloud backup, if you will, of that's what's downloaded when they do these full forensic downloads. So it would be screenshots, it would be voicemails. It wouldn't get into his emails per se, because that would be an additional app, right? So it doesn't go into the WhatsApp app or Snapchat or it doesn't get into apps, but it would download voicemails, text messages, screenshots, all of that. So we are presenting a proposed order to the court, and that is part of our motion to compel that the court sign a order from R3 requesting us to get a copy of Mr. Younger's handheld device. This was also part of a request for production number 84 in our requests, and Mr. Younger responded to that request just saying that same request that he did for everything, that he didn't have access to it, and that was it. So we would like.
Hold on, but he didn't at that point. So my question is, Ms. Clements, do you agree? I mean, I've read Judge R's docket notes. That he ordered they be downloaded. Do you have an issue with the requested order for R3 so that it can be turned over?
Yes, my issue with the order is that it's just so broad. All it says is that pretty much any and all information on that phone is turned over. So it needs to be specific, I guess, on what the court orders today. If it is on the phone, or the computer to be turned over, but it can't just say any and all information on that phone. I mean, there's privileged information, there's information that wasn't even requested in discovery that's irrelevant, like conversations with his mother, for example, predating when the actual discovery requests are asking in that time period. So that's our concern, is just signing some sort of order, or the court is entering in an order that's just so vastly broad and doesn't specify what R3 needs to turn over from that phone dump.
Well, and Ms. Kinsler, I think I did an order in my court for R3 that got appealed, and it was upheld because it was very specific.
Mm-hmm.
You don't get an order that says free for all. I mean, and I'm looking at Judge R's temporary order. Is that set? Here it is. Let me see what he did.
And Your Honor, my response to Ms. Clemens is those are all absolutely valid objections to request for production number 84, where we're asking for a copy of his cell phone contents in possession of R3. And had Ms. Clemens raised those objections timely when discovery was supposed to be produced, then we absolutely would be talking about making that order maybe more narrow. However, those objections were not timely submitted, and therefore they're waived.
But I did not represent Mr. Younger when discovery answers were served. But even if, like, I'm not making any objections today on this motion to compel that weren't raised besides our general objections, but that's a separate issue. That's a distinction versus what is ordered to be turned over on this phone. That's completely separate than this compel hearing on producing documents in response to discovery requests, because that violates constitutional and privacy rights, attorney-client privilege, all of that.
Ms. Clemens' firm was representing Mr. Younger at the time these discovery responses were submitted. So I'm unclear how if that firm is representing Mr. Younger, how we can differentiate now. But specifically, when
that doesn't matter. We're gonna look at the responses, and this is maybe, I typically don't like general objections, but this may be one of those instances when a general objection will suffice, because I have a real problem with, I have a real problem with saying everything on the phone that could include attorney-client privilege. Hold on. I'm looking at hold on. 84, handheld device. Well, it says to turn over any handheld device, which isn't a document, it's a thing. You can't request for production, and now I'm trying to find.
I believe Mr. Younger just popped off again.
And it's almost noon, and I have to give Miss Primo and myself a lunch break because we have these other people coming back at 1. So
absolutely, Your Honor. So page 36 of the motion to compel is the general objections, those blanket objections that normally we do not rely on.
And just for the court to know, Mr. Younger's coming to our office and should be there in 10 minutes.
good, y'all can get him set up for when we come back.
Yes. But my client also can't produce a document that doesn't exist in his possession. He does not have a copy of the cell phone contents from R3.
And
that's why we put no documents were responsive to this request. He does not have that in his possession, still doesn't, as we sit here today.
Miss Kinsler, I think that's right. So you got an order, you say produce the handheld device. Now you're going a step further.
Mm-hmm.
So the RFP doesn't say, and let us download everything. That's Judge Art's order. And I do not believe it is appropriate to have an order that says you can take everything off somebody's handheld device, including privileged information. So I'm going to let y'all talk about that while I take a lunch break. But it's not appropriate to say R3 gets to download everything and you get everything that they download, including his privileged documents.
I understand that, Your Honor. However, I believe they needed to lodge those objections timely.
But your RFP doesn't say everything on it. It says turn over the actual cell phone.
It says contents, Your Honor, a copy of his cell phone contents in possession of R3. But I hear you, Judge.
It says any laptop, cell phone, and any property or device he's used, including, it doesn't say and everything on there. It doesn't say turn over the password, let me download it. That's not what that RFP says. So I'm not
I hear you, Your Honor. I hear
So
you.
why don't y'all work on that? Because I'm not gonna enter an order that says you get a free-for-all, everything that was on his phone, including anything that may be privileged.
We are obviously not trying to get privileged information when we spoke to R3, and I know that time's of the essence, but I want to go through the Compel with Ms. Clemens and this R3 again. R3 had advised that we can limit by date range. That doesn't sound like that would suffice with
No.
what you're requesting.
Y'all ought to look at the case, and it was because before he was a judge, Judge Hayes presented on that at a federal lunch.
Okay.
I remember like, oh, that was my case, and I got affirmed. It was a really specific order, and it was iClinic of Austin, I believe is the name. Y'all try to find that. I'm gonna go ahead and log off so that you don't want a hangry judge and court reporter when you come back. Y'all be ready at 2. Hopefully we'll be ready to go at 2. If I don't log right on at 2, it's because my 1 o'clock hearing hasn't finished, but I'll get to y'all as quickly as possible. Okay.
No problem. Thank you.
Were y'all able to talk about the order concerning R3?
I have sent over, I believe now 3 orders to Ms. Clemens' office, and I asked her for revisions. She represented that they had objections, but I've not seen what those objections are as we sit here.
How do y'all want to proceed? Do you want me to take up the objections and the orders, or should we proceed with the compel enforcement?
I think I would like to proceed with the full compel so you could get a better idea of why R3 is so important, Your Honor.
I'm sorry, Judge, this is Rochelle. My computer just froze, so can Miss
Sure, hold on.
Ms. Kinsler just repeat that? I'm sorry.
I said that I think I would prefer to proceed with the compel so that you can get a better idea of the outstanding discovery issues that might help with the language of R3.
Okay. That's
And
fine.
yeah, if I may just briefly respond about that. So the compel order, I mean, not the compel order, the R3 order. Our issue with that is, I mean, for one, I didn't even realize this was set for an entry hearing today on this.
It's really not set.
Yeah.
That's not even set, and really that's Judge Arth. If y'all had agreed to something and I could, get there, I'm happy to do it. I mean, if I am gonna rule, let's see, it was at 78. I don't believe, Ms. Kinsler, that your request for production 78, it required turning over a device. It doesn't say, and you get everything on the device. So
and that's my concern, Your Honor, right, is I know it's 240. I don't want to, if you're hesitant to, or if we need to set this in front of Judge Arth, I can absolutely do that, because I do know he heard the temporary orders. There's a reason that he included it in the temporary orders. So I do feel like maybe Judge Arth had an idea of what he was expecting R3 to do after hearing the temporary orders. And so if there is a dispute and you're not comfortable, then
it's not set. It's really not set before me. I brought that up. I mean, but so I'll hear the compel, but the form of the R3 order, that is something Judge Arth did, and it's not set, and so.
And Your Honor, when we did do a request for the motion to compel, that was part of our requested relief, was to enter an order allowing R3 to release information requested from the data they collected from Mr. Younger's device. So there is requested relief on file for the R3 order. But I don't want to mess up this order. And if it's more appropriate in front of Judge Arth, I would like to do that.
Did you all read that case I was telling you about? Did you find the case I was talking to you
I
about?
could not, Your Honor. I tried searching generally and was unsuccessful, unfortunately.
Sorry, maybe I'm wrong.
Same,
That's okay.
I found just a like memorandum opinion about it. It wasn't the actual case. It just said that I think they like dismissed their appeal or something, and that was it. That's all I could find.
Well, okay, and I'm sorry, I'm not going to be able to put my hands on it real quick. So let's proceed with what time we have.
Okay. So like I said, we did a proposed order to compel. What we're still missing for the request for production, number 1, bank statements. There is a unknown account ending in 0896. We can see that money was transferred to that account, but we do not know what the account is. I have a copy of that transfer if the court needs to see where we're getting that information. But we're asking that Mr. Younger produce all statements for an unknown account ending in 0896 from January 1, 2020 through present.
Ms. Clements, we're going to take these one at a time. Do you want to respond to that?
Yeah, so it's a Randolph Brooks account. We did produce the one statement that was specified in their deficiency letter to show what those two transactions were for. It's just for an old Chevy truck that our client had, but he does have those statements. He only opened that account in January 2022, so we're fine with producing those statements January 2022 when the account was open to present.
Okay. That'll be the order of the court. Next, you've got RFB 6427.
So there are three additional, if that was an RBFCU account, there are three additional RBFCU accounts that were missing statements. So 6427, we're missing January 1, 2020 through July 31st, 2020, and then November 1, 2020 through December 31st, 2022.
This is a joint account. My client can he can produce those statements, but this is a joint account that Miss Younger's also been on for 10 years.
I am not, my understanding is this is not a joint account. We actually didn't know some of these accounts until recently. He provided a screenshot and none of the statements, and he's cutting off the balance on them. So it was 6427, 6636, and 0337.
I don't see that in your motion to compel.
I believe it was because what was just provided to us this morning or last night, the screenshot of the RFBCU accounts, it was additional RFBCU accounts that we didn't know existed. So we have the 6427, and then we just found out about the 6636 and the 0337.
The last two, 6306 and I think it's 3761, or what my notes show, those are two accounts that he opened after the party separated. And so the only statements he has we produce is from October to present for the last two. And it should show on that account that those were the dates it was open, either October or November.
Problem is that there aren't statements. It's actually just a screenshot of the balance, of not even the balance, just showing. And I think, Sarah, do you want to pull that up, please, of just showing what he produced regarding all of those? It's not actual statements.
Okay, we can produce, I apologize about that. We can produce the full statements, but those two are just accounts that were just opened. The other one, the 6427, my client's telling me that's a joint account. That
You can get him to produce all the accounts for all the statements for all those accounts.
okay.
All right, RFP number 2.
There's some additional under still RFP number 1. There is statements for a Chase account ending in 9873. He, Mr. Younger hasn't, just needs recent supplements. There's also a statement for a Frost account number ending in 0647. Again, this was just disclosed yesterday, so it's not part of the Compel, Your Honor. But random statements were provided, only 4 statements were provided for July through October 2020. And then the rest of the statements were not provided. Again, we didn't know this account existed till yesterday.
Ms. Clements?
The Chase one, again, was something that was opened when he moved out. And again, that is one that we've produced. At the time, it was just November, December 2024. I mean, we can supplement with the most present statements, but that we have.
If you're going to produce it, but Ms. Kinsler, if he did produce the statements that he had up to the time of production, he hasn't done anything wrong. You're now saying an extra supplementation.
No, I agree, Your Honor.
Which I'm okay with, but I mean, I'd rather have you guys get everything, but he's not under an obligation to supplement every month or two.
Yes, ma'am. I absolutely agree. And the Frost account, again, I acknowledge that that wasn't part of the motion to compel. We just didn't know this account existed till last night. So
I believe the Frost account was produced back with the inventory exchange, but same thing. We have no problem producing date opened until present for the Frost. But my client also says that's also been a joint account for 15 years, Frost 0647.
my client didn't know this account existed. So we just, if he can provide, that would be great. There was also again, this wasn't on the compel, but this was a big issue that there was under number 5 on the motion to compel, under request for production number 1, Miss Younger had a IRA check of that was $51,000, and Mr. Younger deposited that into what she thought was the Chase account. We don't know where that check was deposited. I understand probably the better avenue would be for me to do a deposition. However, financially, we were hoping that Mr. Younger could just produce the statement where he deposited that very large check.
So I believe we did. It's Bates number 65 through 114, and it shows on February. Oh no, they were produced February 28th, but my notes show that was in those Bates numbers 65 through 114 and the Chase account ending in 3106. I mean, if it was an inheritance check written to your client, it would have had to have been deposited, through her signing off on it if the check was in her name. But my notes that my paralegal put together show that we did produce those statements, including the actual statement that shows that deposit.
And I don't believe it was deposited into the Chase account. So again, I don't think it's specifically outlined in our compel, Your Honor. So I'm going to go ahead and move on.
Thank you.
The request for production number 3, there were approximately 4 deposits that when Mr. Younger opened these new accounts, there were several large deposits, and we don't know where they came from. So we're asking for the check deposit slips.
You just said number 3. I think you mean number 2 for canceled checks, right?
Yes, Your Honor. Request for production number 2, deposit slips. Yes.
Thank you.
And so the exact is A, 6,500 on November 30th, B, 2,430 on November 22nd, 2024, C, 1,475 on December 23rd, and then the last one, 491.25 on December 23rd. So we have proof of C on the motion to compel, the 4,975, but we need the other 4 deposit slips.
We can get that. I believe it. I didn't realize it was, you're saying just screenshots were produced, but all of those statements should have been produced, but we will get those produced and turned over. My client says that was from his Chase 9873 and that we produced all of those statements except for December 2024 to present.
Well, they're asking for deposit slips or the source of the following deposits. So I'm not sure the statement itself will show the source of that deposit, and if they have deposit slips.
Correct. I don't know.
Okay.
Well, we can get that for you, Ms. Kinsler. That's not an issue.
Request for production number 4, Mr. Younger produced the TCDR pension, but we are missing statements from his 401k. We're missing January 1, 2020 through September 30th, 2024. And it's his Thermo Fisher 401k.
he didn't start working for Thermal Fisher until 2022, but the statement since then, I believe we produced October 2024 to February 2025. We will produce from 2022 through September 2024 for Thermal Fisher from date of employment through September 2024. We'll supplement.
You. The credit cards, confirmation if Mr. Younger has a Venmo credit card and to produce those statements. The Home Depot credit card, from January 1, 2020, and then the city credit card from January 1, 2023 until August 31st, 2024. We received the Discover credit cards statements.
The Venmo statements, we can supplement on the dates missing. I believe it would just be through December 2022.
I don't think, and I want to be clear, Ms. Clemens, this is a Venmo credit card, not just a Venmo app.
Okay. All right, well, we can produce the Venmo credit card. The Home Depot, my client did just send us on the break. We have that now. And then you said the city credit card.
From January 1, 2023 through August 31st, 2024.
My notes show we produced everything.
Sarah, do you want to pull up the city credit card, please?
Right, so on that one, you just need for the year 2023?
2023 through August 2024. So like you can see what's been produced, we combined it. So you have some through 2022, and then for whatever reason, it skips to September 24th. I'm sorry, September 2024.
Okay. We can do that.
We are asking for copies of request for production number 16. We would like Mr. Younger's W-2s or other income reporting documents for 2024.
He doesn't have that yet, or at least he hasn't received it from his employer, but he can go request his 2024 W-2 and produce it when he does receive that. But all other W-2s from 2020 and all tax returns prior to that were produced.
Right, we're just down to the 2024 W-2. And you're saying that Mr. Younger wasn't provided that yet?
Right, I don't believe that he has received that yet. It might just be on his, employee pay account. It hasn't downloaded it yet. I'm not sure, but we can get the 2024 W-2.
Request for production number 20. We are asking for all closing documents for real estate presently owned, and then copies of unredacted leases and rental agreements for any of the parties' rental properties, and then copies of receipts and documents pertaining to maintenance of and improvements made to the properties. For request for production 20 specifically, there have been, as of last night, claims for separate property now that are new. And so I'm just asking that all of that documents be, if we're making a claim for a separate property, that we have the closing statements and the tracing. So we are asking that that be produced. The more important part of request for production, 20 is the copies of unredacted leases and rental agreements for any of the parties' rental properties. Under the temporary orders, Ms. Younger is responsible for managing the rental properties now, and Mr. Younger sent the leases and rental agreements with all of the tenants' names and contact information redacted. And Ms. Younger, between that and you'll hear the enforcement issues of not having access to some of the websites that help run these properties, has put Ms. Younger at a disadvantage of trying to keep the business up and running. So we are asking for these unredacted leases and rental agreements.
So on this one, the first of all, my client has produced everything on the closing documents and rental agreements that is currently in his possession. He's produced 4 different leases. He's reporting that most of all of their documents, they've always kept in a file cabinet at the marital residence, and he doesn't have copies of any of that. And then what might be on his MacBook Pro has now, his MacBook isn't working. That's what R3 Forensics took anyways. And so what he has, he's produced. It might be something where one of us is going to have to send out a subpoena for what's missing. And that's been an issue too with proving these separate property claims, is that we don't have all of these documents. Anything that he has to date, we have turned over. But I know there's Blue Moon's Forms, I guess, is where they store a bunch of their leases as well, that I believe Alicia, or Miss Younger, excuse me, has access to. And then I also just wanted to clarify, we're only talking about producing current lease agreements, right? You all aren't asking for prior
No.
tenants, right?
No.
Okay.
No.
So on the
And-
lease agreements, he has produced the 4 leases that he has for both the Cherry Park properties, Gilmore and Mullen. Those are the only ones that he currently has. Anything else is either in the file cabinet at the marital residence or on his MacBook that he needs to take to the Apple store and get fixed. He doesn't have access to that.
Well, my issues with the redaction, Your Honor, I'm unclear of who did the redaction on these leases. So I'd like it if we can be provided unredacted leases. I would like that.
Ms. Clemens, do you know if he has any unredacted copies?
Can I
That's
ask?
not-
Fine.
Yeah, you can't. Of course, it's not the RF. The motion doesn't say that. It just says copies of the lease agreements. But if they're redacted, they're entitled to have them unredacted.
Okay, if it was redacted, we will send an unredacted copy. But again, I think a lot of the closing documents and everything, I mean, these parties, Your Honor, have, 10 or so rental properties, and some of them date back to purchase all the way back to 2002. So what he has been able to find with his new computer, and what's not at the marital residence, we have produced, but I think we're just going to have to start like subpoenaing, old bank statements. Yeah, but he's produced what he has about the closing documents.
As I said, my concern was just the leases, just unredacted leases. I understand, and that would be the same then for request for production number 21, real estate sold, that if Mr. Younger has anything else that he produce. Request for production number 22, we asked for Mr. Younger's Penn Mutual Insurance. Mr. Younger has a history of taking out whole life insurance policies and taking loans out on them. And so we'd like to see what life insurance policies have been taken out. Just all the information. Who are they? Some of the life insurance policies are insuring Miss Younger. And so we're just asking for all of these life insurance policies, Your Honor.
Ms. Clemens?
I mean, I don't really see how this one is relevant. It's not trying to hide anything. If you want us to go and pull these documents, I can ask Mr. Younger to see what he can
He has
find.
produced documents in his actual care, custody, or control, or that he has access to, but the issue is, if they're not objected to, you got to produce them, whether you think they're relevant or not. Right?
I understand, and that I just want to make it clear that was an attorney prior to me, but so we will get the insurance documents for Penn Mutual. Are you wanting from 2020 to present for that, Colleen?
I believe that's the dates, yes.
Okay.
I think 2020 is fine for now.
Okay.
Request number 23, a copy of the lease agreement where Mr. Younger is currently residing.
Yes, we can get that to you.
Request for production number 24. It's our understanding that Mr. Younger just purchased a new vehicle, and so we were requesting all information regarding the purchase and the loans on that motor vehicle.
So he doesn't have any documents for this. He hasn't actually purchased it yet. I know Judge Arth made a big deal about how if Mr. Younger didn't have a vehicle, he should go out and get one, and he had permission to do that. So he is driving a 15-year-old Volkswagen of one of his friends, but title actually hasn't been signed over yet, nor has he paid his friend yet. So there are no documents as of right now to produce in response to this request. But we will supplement if and when he purchases the vehicle and obtains title.
Okay. Request for number 36, the Mr. Younger's credit report.
Yes, we received that early this morning. We can supplement and give that to you.
Okay. I think request number 37, again, like I said, separate property was raised last night. If you all have anything, please produce. Request number 51 is expenditures on other persons. Mr. Younger didn't produce anything under request number 51. And he testified during the temporary orders hearing that he has previously paid for escorts and taken these third-party shopping, that he's purchased gifts for paramours, that he's paid for medical bills for some of these people. So we were asking for Amazon purchase history, airline itineraries, receipts, any money that Mr. Younger has spent on any of these third parties. Further, there were specific funds spent to a dentist, Dr. William Burkhart. And we outlined A through D, which Mr. Younger provided last night, but E, where he paid in October 2024 to Dr. Burkhart, we'd like the receipt of showing what that was for. So basically any expenditures for other people.
And I just wanted to clarify, I don't believe anything was said about money spent on escorts in the temporary orders hearing, but Amazon, my client doesn't have access to that. Ms. Younger deleted him from the Amazon account after the divorce was filed. So she would have access to the Amazon purchase history. No flights have been purchased for any other people. So there are no documents to produce for that. And then I think anything else would fall into, bank statements, Venmo, other things like that that have already been previously produced or we are agreeing to supplement.
And I guess my client has represented that she did not close down an Amazon account. I don't know how we prove the negative, Your Honor.
I don't either. And I don't know how you want me to rule on that.
I know, Your Honor. I'm sorry. If Mr. Younger could please provide his attempts to log into Amazon or the email showing that his account has been deleted, if we could start there on that issue. And then if we need to be back, we'll be back.
Okay, we can do that. Dr. Burkhart, we have the full statement report as of this morning that I can send to you with just that last transaction. That's for a dentist. We can provide that.
Thank you. Request number 63, Mr. Younger did not produce anything. So no videos, photos, screen recordings, or any other items depicting any of his dates, his interactions with paramours, escorts. We know that they exist. That was part of what was deleted that we're trying to get from R3. So we know they exist, and we also ask that Mr. Younger provide videos, phones, anything regarding all videos, photos, screen recordings, or screenshots of minor children other than Benjamin. That it was specifically in our Compel.
Again, he doesn't have his phone, so he has nothing on his current phone responsive to this request. R3 Forensic is holding his phone and computer.
That's just not accurate, Your Honor. Mr. Younger got himself a new phone. He has a computer where he downloaded, right?
She just said, other than his new phone.
I'm sorry, Your
have
Honor.
no idea if his new phone has any of those things. I mean, what I heard Ms. Clement say is he doesn't have the phone that would have those things on it.
He has a computer with the cloud on it now, where that would have backed up all of his other, all of his information. So right now he is sitting here with a computer with cloud access. So everything that was deleted off of his laptop when he set it to lost mode with R3, he now has that on his, whatever he backed up to his cloud, he has the ability to produce videos, photos, anything in his possession. And so the fact that not one single document was provided at all to number 63, I find that hard, that there wasn't anything in Mr. Younger's cloud to address anything under 63.
Ms. Clements?
I mean, again, I don't believe that he has his phone or his computer. That's why R3 Forensics needs that order. He doesn't have any of that.
If you ask your client if he's able to get to the cloud, if there's anything backed up on the cloud that he can get to with his new computer. I mean, Ms. Kinsler is making an assumption. I don't know if that's a good assumption or not. Everybody doesn't back things up to the cloud, but if he does, he needs to produce it. I don't know.
I can ask him that.
Okay, to the extent he can get anything from the cloud responsive, he has to produce it. If he can get it, but let's be clear, if the rest of it's on the devices that R3 has, he can't produce things that R3 has.
Absolutely, Your Honor. Request for production number 66, email and text correspondence and other electronic communication. We've asked for copies of all messages, whether text, email, the sugardaddy.com website, Instagram, WhatsApp, Facebook, Signal, or any other means of communication. And we specifically laid out the people that we were wanting to get the communication with. No documents were provided in responsive to 1, 2, 3 under request for production number 66. Nothing has been provided.
So again, this is all on his old phone and computer, but most of these people, Jake is a handyman that they 1099 every year that does improvements on their properties. I don't see how that's relevant for his communications with their handyman. Miss Younger's
okay, let's go back. That's the same as, it doesn't matter whether you think it's relevant if it wasn't objected to, does it?
right.
Does he have access to it from his new devices?
No, and that's what he's reporting to me, is that this is all on his old, and I mean, that's what the R3 order, I guess, that Judge Arth will clarify. And that can be an issue that Judge Arth can address on what communications and whatnot need to be turned over between these people. But these are their tenants, their barber, their handyman. Three of these women are women that he openly admitted in his interrogatories and in court that he has had an intimate relationship with. So he's not hiding anything. He's been open with this court. It's really just a fishing expedition to get messages from all of these people to see what might be there when he's already admitted to being
Okay.
unfaithful during the marriage.
Let me go back to what I've said a couple of times. Was there an objection made?
There was not.
Well, then what is the answer to that if no objection was made? You don't get to decide what was relevant. What is relevant?
I hear you, Your Honor. I apologize. I'm just saying what my client is saying is that all of this is on. He doesn't have any of these communications with any of these people on the brand new phone that he's purchased since the divorce was filed. This is all on these old devices.
All right, well, the order will be he has to produce anything on the new devices.
And Your Honor, I guess I want to be very clear. R3 cannot get into Mr. Younger's WhatsApp app or his Facebook app and download those messages, right? Mr. Younger has his login and password so that he can log in to sugardaddy.com, log in with his account login and password, and all of that will come back up. That's not something that's saved to a program where R3 would be able to download it. It would be the same as you and I logging into a Gmail account. These are external programs that R3 cannot access. So Mr. Younger just logs into Instagram or logs into sugardaddy.com, and all of that will be there on any computer. He could do that in a library if he wanted to. So I guess I just want to be clear that this representation that he doesn't have access to it, R3 can't get this information.
Well, I hear what you're saying, Colleen. His Instagram account was deleted a long time ago. He doesn't have an Instagram account anymore. Some of these things, I think there's a dual authentication feature that he can't get in at this point because, again, it's connected to the old phone and the old computer. But to the extent that we can, I guess we will try again. I don't know, Judge, if you want him to execute an affidavit of what he's not able to get or what accounts have been deactivated.
He can, I mean, I was going to say, if I lost my phone and I have my password saved on my phone and my computer, and then I didn't have access to them, I probably couldn't get into some of the kind of programs you're talking about. To the extent that he can, he's ordered to. And if he can't, he needs to do an affidavit saying why he can't open any of those programs.
And I guess the same thing would apply to the next request, number 67. These Instagram communications with these Instagram handles.
Yes, I'm actually surprised to hear that Mr. Younger canceled his Instagram account, and I'm interested to hear when that happened. But yes, we would like this communication.
To the extent he has them and has access to them, he has to produce them. If he can't produce them, he needs to do an affidavit that says why.
In the affidavit, can we include when the accounts were closed, Your Honor?
If they want to. I'm not really here to let you, I mean, this is a motion to compel. As you said earlier, that might be scope for deposition. I'd love to, if they want to do it and it saves everybody time and money, I'm all about it. But I don't think I have a pleading before me that can require him to do that. Can I, Ms. Kinsler?
No, Your Honor.
But it makes sense that he would, and I would encourage him to. Okay, let's. It's 3. We're going to finish this, then we're going to have to take a break because
Yes.
we've been at it since Ms. Primo and I since 1 o'clock.
Absolutely, Your Honor. request for production number 82 is, sorry, Your Honor, I'm trying to make sure that what was included in our motion is the same of what I'm asking for as I sit here in front of you. Yes. So for request for production number 82, we are asking for the Cash App statements. Specifically, when you look at request for production number 82, it's number 3, which is Cash App statements from January 1, 2020, we outlined because some were produced. Additionally, during the temporary orders, Mr. Younger stated that he has a Cash App in the name of Mark Z, and Mark Z is actually his Cash App account. And so we're requesting, in addition to his generally Cash App account for Mr. Younger, that anything under Mark Z is also provided.
We can produce the Cash App statements that we didn't during that time period. It's my understanding it's the same account for Mark Z and the Cash App, but if I'm incorrect on that, yes, we can give you the Cash App statements. I think most have been produced, but yes, that haven't, we will get that.
And then we're asking for Mr. Younger's Apple Pay transactions. Specifically, when it shows up on the bank statement, we're seeing that there were payments through apple.com bill pay with an amount, but we don't know what it was actually paid for. We can't see that unless we get the iTunes and Apple purchases, those details.
Ms. Clements?
I believe we produced the Apple credit card statements. Same thing though, if there's something missing, yes, we will get it for you in that time period, but I think this was all supplemented yesterday.
The next one for request number 82 was statements from Mr. Younger's Zelle account. I'm gonna move along on that one. I think that that's all going to show up on his bank accounts. I don't believe you get a separate Zelle statement, so I'm going to revoke that one. Request for production 84 was the R3 that we have talked about. Request for production number 85, we asked for a copy of Mr. Younger's search history on his browser for any computer he's used since January 1, 2020.
I guess that would include the computer he has now, but if the other one isn't R3, R3 has it, I don't know how he's going to do that.
And that is one thing that we were proposing in the R3 order, but we'll, I guess, deal with that for another day. Computer now, update, and then olds will be the R3 order. Request for production number 86, Mr. Younger's social media, any documents regarding any of his social media accounts?
So again, I think if it's, what's specifically asked for in the request under 86, and again, if it's what he has on his current computer or that he's able to log in and get, yes, we can supplement.
Request for production 89, any of Mr. Younger's dating profiles?
I think same thing as what we said before, what he's able to access with the current computers that he can get, he will supplement.
And then, Your Honor, I have attorney's fees laid out, separated by the enforcement and the compel. I know you want to take a break, so we can reserve that till the end of the hearing if you'd like, or I can do a quick proof of it all.
I think it makes sense to do it all at once.
Yes,
So
Your Honor.
it's 3:25. Let's be on break for 15 minutes.
Thank you, Your Honor.
Thank you. All right. Ms. Kinsler, we're going to go next to the motion for enforcement.
Yes, Your Honor, if we could just go back to the compel for a second. I was just notified that Mr. Younger actually got his phone and laptop returned to him on January 28th, 2025. So I'd like to revisit the affidavit issue, I guess, of the representations that he can't have it or he doesn't have access to anything because he doesn't have those devices anymore.
Mr. Younger, turn off. Let me ask you directly. Did you get your phone and your computer returned to you on January 28th?
I did have it returned to me. I think it was before January 28th. I think it
So
was closer to the 15th or something of January.
I gather Ms. Clements didn't realize that. So our whole discussion we just had about things that you can't produce because they're on the devices you don't have would not be true, correct?
That is incorrect because I just never upload the cloud and it was 10 years old and I didn't even have my sister's phone numbers. So even with being able to log in and get previous numbers and passwords and people and contacts, I couldn't find tenants. It took my sisters 3 months to find me. And the numbers I had were from 15 years ago when they were married to completely separate people. I couldn't even find them. And it was I just never uploaded, you upload to the cloud, I guess, regularly. I never did, rarely. It was very old.
Well, but you have the ability, then you need to go through and any of those things that are on those devices. Are you able to take the computer that R3 couldn't get open? Can you get that? Has that been fixed? Are you able to restore what was on there?
The computer, I have not been able to restore anything that's on there. I have not got a chance to bring it to a Geek Squad or a computer person that knows what they're doing. It just won't boot up at all.
Okay, so wait, you've had it since maybe January 15th. We're now on March 5th, and you haven't taken it to see if you can get it restored.
That is correct. I just bought a new computer.
Okay. Then I think I'm going to order you to take it and see if you can get that fixed and restored. And if so, you're ordered to produce any documents that were requested and you have on your computer that are responsive.
I'm happy to, Your Honor.
And I guess for clarification, Your Honor, Mr. Younger is acting that his cell phone was deleted also, but nothing was deleted from his cell phone. No one deleted his cell phone. His cell phone wasn't set to delete like the laptop was by Mr. Younger, right? Like Mr. Younger was the one who, through cloud, set the laptop to that it was stolen so that when someone tried to access it, it was wiped. Mr. Younger did that. He wasn't able to do that on his cell phone. So his cell phone is still intact.
You're saying that, Ms. Kinsler, I don't know if I need to swear him in and we need to take some testimony about that, but I don't know that any of that's true. I don't know that you know that any of that's true. Do you want to call him and let's figure it out? But I'm not just going to make assumptions like that.
You know what? I'm okay with it because I believe that it was testified to through R3 or it was testified to Judge Arth. I just wanted to let you know that the representations that Mr. Younger doesn't have these devices or doesn't have access to be able to log in, this two-step authentication that they were saying he can't get is not accurate because he does have his devices. That's what I was just trying to point out to the court, Your Honor.
Okay, well, he's ordered to produce any responsive documents that he has and that he can gain access to. What's next?
That would be the motion for enforcement, Your Honor.
working off the amended motion for enforcement filed on February 25th, 25? All
Yes, Your Honor.
right, you may proceed.
I'd like to call my client.
Ms. Younger, if you'd unmute yourself.
And are you currently married to Sabarian Younger?
I am.
And did you and Mr. Younger have a temporary orders hearing on January 6, 2025?
Yes.
And was an order rendered that day? Did the judge issue a ruling on that day?
Yes.
And was a final or a temporary order then subsequently entered on February 5th, 2025?
Yes.
Your Honor, at this time, I would like to move for a directed verdict on this enforcement. It's not specific enough. It doesn't say, the who, what, when, what he's ordered to do and when he's ordered to do it.
Well, I don't think I can do that till she puts on the evidence about it. So that's a little premature, Miss Clements. You may be right, but it's a little early. Well, I guess actually we started. Oh, you can each make a brief opening and you can tell me that, in your argument, Miss Clements, and as I'm looking at it. So, Ms. Kinsler, you haven't told me what relief are you seeking?
Absolutely, Your Honor. And what I will be offering is Petitioner's Exhibit 1. Let me share that with the court. Your Honor, as we discussed, we were here for compel order that we just went through. The second issue is Ms. Younger's first amended motion for enforcement of temporary orders. Specifically, the parties had a hearing in front of Judge Arth on January 6th. Temporary orders were subsequently entered on February 5th, 2025. In these temporary orders, there were several items that Mr. Young was supposed to do, specifically to let Miss Alicia Younger take over and help run the rental properties, right? As was testified to earlier, there are several. Miss Younger, under these temporary orders, was ordered to run these properties. One of the specific things that Mr. Younger was ordered to do was to transfer management of these properties to Miss Younger by getting her access to apartments.com, which gives her the ability to see tenants, give them access. Miss Younger that was all supposed to be done by January 15th, 2025. Mr. Younger has not done that successfully. Additionally, Mr. Younger was supposed to remove Miss Younger as authorized user on her his credit cards because it's affecting Miss Younger's credit. He was supposed to do that by February 6th. We were given proof that this was done this morning before the hearing for the first time. Under violation number 3, Miss Younger had to pay the 2023 California income tax liability under the language ordered on page 14 and 15. Mr. Younger was supposed to pay 50% of that within 7 days of request. Miss Younger sent that to Mr. Younger's counsel at the beginning of January, and those funds were not provided. Violation number 4.
I can read it. We can go over it. I don't need you to read me your motion, just so. And
overall, those are the issues. We just have basic stuff that's not happening. And Mr. Younger today, for the first time, started trying to make efforts to give Miss Younger access, and it's not successful. And we'll go through how that is affecting Miss Younger's ability to keep all of these properties up and running, which then gets us to the motion for further temporary orders. The parties have a balloon mortgage payment coming up on one of their properties in California. It's going to be at an accelerated loan with a balance of $347,000. The parties do not have the ability to pay off that loan, refinance. It doesn't make sense to sell that property because there's so much equity in it. However, my client is requesting that we sell 3 other properties in the Austin area that are currently losing profit, that they are not making every month, that they're losing money every month. And my client is requesting that she be able to sell 3 properties to be able to pay down that accelerated loan. And then also pay down the tax liens on the Woodruff property and the electrical repairs on the Woodruff property. My client is also asking that if the language of the enforcement is not specific enough to order Mr. Younger to pay 50% of the California income tax liability, that he's ordered to do that under the further temporary orders, along with 50% of the CPA fees for 2023 that are currently outstanding and owed.
Can you point me to the language and the existing temporary orders that you think requires him to pay 50% of the California taxes and the CPA?
Absolutely, Your Honor. If you look at the bottom of page 14, where it says management of rental properties, it says that Ms. Younger is responsible for managing to make sure all of these assets and responsibilities are attended to. So the bottom of page 14, it says paying taxes. And then
I see that. Where does it say we got to pay half of it?
Right. On page 15, the very middle of the page, right above R3 forensic, it says Alicia Younger is ordered to use all rents received for the properties towards the mortgage payment of the properties. And then it says, in the event the rental income is insufficient to maintain the property expenses, the parties shall be equally responsible for the deficit and split all remaining expenses 50-50 with reimbursement within 7 days of request.
All right. That's your opening. All right, Ms. Clements.
Sure, Your Honor. I would like to just reiterate, I believe once Ms. Kinsler has called Ms. Younger and she's asked her one question, the double jeopardy attaches, and in the interest of justice and pushing this enforcement along, I can move for a directed verdict at that time and make those arguments. If the court would like to wait, I can wait until...
Well, I don't know. Double jeopardy, isn't that a concept that comes up in criminal courts?
Well, when there's contempt being asked.
Well,
Asking for criminal contempt, Your Honor.
this isn't a criminal contempt. They're not asking for jail time.
They're asking for civil contempt in their motion.
You can brief that for me, but I've never had that come up. I've done this for a long time. I think that's a criminal law concept.
Okay.
So
I'll wait then on that. I will say on the temporary orders, well, going back to the enforcement, I believe the evidence will show it's an untrue statement that all of these things were just done last night. We have emails where these parties were trying to work this out back in January, had agreements to do certain things. My client tried to get her on the apartments.com account, has tried to do all of these things. So I just wanted to point out, I don't believe that's a true statement to say this is all something he tried to do last night. On the temporary orders, we agree properties need to be sold. We're in agreement with selling the Mullen Drive and Gilmore Street property. The issue is Lakeview Cove. My client has separate property claims for Lakeview Cove, and this court cannot divest him of his separate property. Temporary orders are at final, and separate property claims, that's an issue for final. Like I said in the motion to compel, documents, we're still trying to produce and gather those documents, but essentially Mr. Younger owned this house, Turkey Trot, prior to marriage in 2002, he did a cash out refi of that and used those funds to purchase Lakeview Cove along with a couple of the other rental properties, not none of which they're asking right now that currently be sold. But our position is Lakeview, they're separate property claims. That's an issue for final hearing for the court to determine separate property claims. So that home cannot be sold today, but we are in agreement with selling Mullen Drive and Gilmore. And I think that should resolve the temporary orders issue, and that's our position.
Yeah, I appreciate that. I'm kind of amazed that have y'all discussed this?
I
Try.
did yesterday.
Okay, so you knew before you got here, Ms. Kinsler, that they've agreed to sell Mullen Drive and Glenview?
I did know that they were willing to sell those two properties. I don't think there's enough equity to, I think we need a third property sold, Your Honor.
Well, if anybody testifies that he believes he's got a separate property interest in one of the ones you are asking to be sold, I'm not gonna, with the discovery's ongoing, what if it is a separate property?
I have a deed to present, Your Honor, for the property that we're asking to be sold that says it was Mr. and Mr. Younger. That's I have the deed that says it was purchased by a married couple during the marriage.
Okay, is there a claim that separate property money went into the purchase? What's this?
That's exactly what we're saying. The cash out refi from Mr. Younger's separate property home owned prior to marriage in Turkey Trot was used for the down payment for Lakeview Cove. That's exactly what our position is.
And Your Honor, my client's going to testify that Turkey Trot, Lakeview was sold prior to Turkey Trot being sold.
Not sold from the cash out refi though, Colleen. I'm not saying sold.
Like I said, we have the documents for this property. I understand where you're coming from, Your Honor. I was hesitant, right? I feel like we have a paper trail to show this. And so.
Do you have the documents from Turkey Trot? Do we have a tracing from Turkey Trot where the money went to Turkey Trot?
No, Your Honor. I've requested that.
Okay. Well, I'll let you put on your evidence. We've got an hour. I'd like to get this done.
Yes.
But if there's discoveries ongoing and I've got a claim that it can be traced, I'm going to be hard pressed to sell something that has a separate property component.
Yes, Your Honor.
A potential separate property component.
That seemed to be the plan. Would you like me to proceed with putting my client on, Your Honor?
Yes, you may.
Okay. All right. Ms. Younger, we prepared a proposed disposition of issues in this matter as Petitioner's Exhibit 1. Is this your requested relief to the court today?
Yes.
Okay. And we went through this yesterday as well, right?
Yes.
Okay. I want to just very specifically go through everything with you. Talk to me about the apartments.com. What access do you have as we sit here today?
As we sit here today, I have no access. Mr. Younger provided a password to get into apartments.com 3 weeks ago, somewhere in that vicinity. But I was only able to see the home screen. I was not able to see any information about properties or renters without two-factor authentication, which went to his email and his phone. And you could choose either one. So he could use saberproperties@gmail.com for that authentication. Then at some point within the last 3 weeks, he changed the password. So then I had zero access to it. And last night he messaged me on Our Family Wizard and provided a different password. So I at this point, I haven't tried to get into it. It's kind of a runaround and just a circular, you can see the homepage, but you can't see anything else. And for a free website, it's a massive amount of money and legal fees.
What do you need Mr. Younger to do as we sit here in court today?
I need him to go into apartments.com and change the contact information to my information. Then they will send the authentication to my phone or email, and I can verify it from here. Then it will be set. But it can't be set if they're trying to send me verifications that I can't give within the 5-minute time frame. So it needs to be done all at one time.
Your Honor, I'd like to offer Petitioner's Exhibit 1 as my client's proposed disposition of issues.
No objection.
One is admitted.
And then to I'm trying to pull up Petitioner's Exhibit 2, and for whatever reason, it's not showing up. Ms. Younger, I'm showing you what's been marked as Petitioner's Exhibit 2. Are these the temporary orders that were entered in your case based off the hearing you had on January 6, 2025?
Yes.
Your Honor, I'd like to offer Petitioner's Exhibit 2 and ask the court to take judicial notice of the temporary orders that are in the file and signed February 2025.
No objection.
Petitioners 2 is admitted. For time's sake, if you just ask me to take judicial notice, I've got the file here if you have other things.
Thank you, Your Honor. And Ms. Younger, I'm going to go through the language that we're talking about for each violation of what we're requesting. So specifically here, Mr. Younger was ordered to cooperate in transferring the management of these properties to you by contacting apartments.com to authorize Ms. Younger to solely carry out such a task no later than January 15th. Has Mr. Younger done that by January 15th?
No.
Okay. Violation number 2, we are requesting that Mr. Younger remove you as an authorized user from all of his from all credit cards in his name. When were you first provided notice that he had removed you as a user?
Last night. And then the other part of them, I think, came through this morning. So,
okay. And pursuant to the court order on page 14, when was Mr. Younger supposed to be, according to page 14, Mr. Younger was ordered to remove you as an authorized user on or before February 6th, 2025. Did you get those email confirmations showing that prior to February 6th, 2025?
no.
Okay. Violation number 3, you're asking that Mr. Younger split the remaining balance of the 2023 tax liability. Did you pay 100% of that tax liability?
Yes.
And was it your understanding that at the bottom of page 14, part of the expenses that were supposed to be split was when it says paying taxes, that had to do with the income taxes for California?
Yes.
Okay. And according to page 14, in the event that you didn't have enough rental income to maintain those expenses, did you send Mr. Younger notice that you needed him to pay half of the property taxes?
Yes.
And when do you, I'll come back to that.
I'm confused. Okay, let me stop you. You said earlier income taxes. Now you said property taxes. What kind of taxes are we talking about?
It's income taxes, Your Honor. It's state income tax for California.
And there's already a return done?
It was the 2023 already return done. Yes.
And does it have to do with anything except the properties?
Does not. It only has to do with the properties.
All right.
Let's see. Now, violation 4, Mr. Younger was supposed to contact Colonial Mortgage to designate you as a successor of interest so that you have online access. Did he do that?
No.
Okay. And we have it open right now. It's on this page. Contact Colonial and designate her as the successor. And he was supposed to do that by January 15th, 2025. Do you currently have access to Colonial Mortgage?
I do not.
Okay. And what is missing for you to be able to have, or what steps has Mr. Younger done to give you access?
So last night, when his counsel sent an email assuring us that I had access, I called them immediately to check on that because I'm often assured things that aren't true. So I called and I still do not have access. They cannot talk to me about the mortgage. They did tell me that there was a note on the account that he had sent an email, but that they had requested a wet signature in order to process that request, and he did not provide a wet signature on his email. So he did part of it, but he didn't give the most important detail, which is a wet signature.
And according to the court order, was Mr. Younger supposed to do this by January 15th, 2025?
Yes.
Okay. What happens when you don't have access to the Colonial Mortgage?
There are a few things that have come up. The first one is that he had that mortgage set up to auto pay twice a month, half and half, so that you make a payment every other week. You get like an extra payment in per year through a bank account that's no longer open. Without access, I'm not able to change that situation. And so they continue to try to pull money from a closed account, which results in non-sufficient fund fees from Colonial every single month. So at this point, it's over $200 in fees that we have to pay. I also cannot pay the mortgage without incurring a $25 over the phone payment fee. So I can't pay the mortgage online. I can't set it up for auto pay through the business bank account, which is where Judge Arth ordered everything to be paid from. I can't make any changes to it. So we just keep incurring fees.
Okay. And so Mr. Younger just needs to provide an actual signature to Colonial Mortgage via fax or a letter, and then that gets you access?
That's it. They just need a wet signature, as banks often do. They need to, and you know, they need that faxed for security issues. But he could call them and see if they would accept that, a wet signature through email, or if there's any other way for them to do that. Like I said, they can't talk to me in detail about this, but they can talk to him. So if I was able to find out that a wet signature was needed, there may be other details that they didn't share with me. I wouldn't know, but I can guess that they told him that.
Okay. And then the fifth violation is the past due HOA fees for what property?
That would be for the same property for the condo at Mullen Drive. The HOA fees were from 2024. They were from September, October, December, and January.
Okay. And pursuant to the court order, you believe that, or you didn't have rental income sufficient enough to pay those HOA fees. So on this page, it says specifically that if there isn't enough, then Mr. Younger would be responsible for 50% of the HOA fees within 7 days of request. Is that right?
Yes.
Okay. I'm showing you what's been marked as Petitioner's Exhibit 6. Do you recognize this email?
Yes.
Was this the email that Ms. Rosval sent to Mr. Younger's attorneys asking them for the payment of these expenses?
Yes.
Your Honor, I'd like to offer Petitioner's Exhibit 6.
No objection.
P6 is admitted.
I'll show you Petitioner's Exhibit 7. What date is this email?
Friday, February 14th.
Okay. And was this from our office to Ms. Badgett and Mr. Younger's counsel?
Yes.
And this is where we were again trying to point out the tax bill, unpaid HOAs, and requesting that he pay 50%?
Yes.
Okay. And as we sit here today, he has not paid.
He has not.
Your Honor, I'd like to offer Petitioner's Exhibit 7.
No objection.
P7 is admitted.
And Your Honor, do you want proof of the tax payments? You know what, I'm going to move on, Your Honor. Ms. Younger, if for whatever reason the enforcement language is not specific enough regarding the payment of the HOA fees or 50% of the California income tax liability, if the current temporary orders are not specific enough to order that Mr. Younger pay that 50% to you, are you asking in the further temporary orders that he be ordered to pay that?
Yes.
I'll pass the witness, Your Honor.
Ms. Clements,
Okay, Your Honor, at this time, I would re-urge my motion for a directed verdict. I don't believe that this motion for enforcement is specific enough to allege when something was due, what Mr. Younger specifically was ordered to do. The temporary orders itself allege violations that predate from when the order was actually reduced to writing by Judge Arth. The order doesn't have command language. It says on 2 different violations that Mr. Younger is ordered to cooperate with Miss Younger on doing these things. There is no, he is commanded to do X, Y, and Z things. So he doesn't know, for example, on the credit cards, which credit cards he was supposed to remove her as an authorized user on, the income tax liability. I don't believe that that is part of property expenses, nor should a reasonable person understand that that means paying property expenses, or that property expenses means paying income tax liability. Miss Younger then just testified that part of the figure that she's asking that Mr. Younger is to pay is part of the accountant's fees to do the 2024 taxes, which he has no issue with paying. I have communicated that to Ms. Kinsler yesterday. He will pay the fees so that the accountant can move forward and do the taxes for 2024. But again, the enforcement itself, each of the 5 violations are not specific enough. Moreover, violations 4 and 5 are part of the amended enforcement. There's not 10 days notice of that. So I think you can only go forward on violations 1, 2, and 3 from the original enforcement that was filed over 10 days ago.
the amended motion was filed on the 25th and today's the 5th.
Right, I believe that was 7 days ago.
Okay. Well, you may have you may have a point on the amended motion. We can look at that. But as to your other requests, it unlike a criminal charge, her motion does say if any of the language is not specific enough to support a violation, then ask me to clarify, which I can do.
Okay.
So that motion is denied.
All right, Ms. Younger, you on violation 1, you mentioned that 3 weeks ago, my client did provide you access and a password to get into apartments.com, right?
No.
You just testified to that with Ms. Kinsler.
No, I testified that he gave me partial access, not full access.
Okay, but he provided a password to you 3 weeks ago to get onto apartments.com.
Yes, and then he changed the password at some point.
All
So I
right.
could no longer access it.
And then you also testified the issue is that there's a two-factor authentication like code that needs to happen simultaneously, right? That's what the issue is, that you have the password, but you and him need to be communicating at the same time when you're trying to log on to get onto that website, right?
Yes.
Okay. And so in the enforcement or in the temporary orders you acknowledge, it just says you all are ordered to cooperate for you to get onto the account, right?
Yes.
He provided a password 3 weeks ago, correct?
Yes.
Prior to you filing this enforcement, which you filed on February 2020 or February 25th, yes?
I'm sorry, is that a question?
Yes, my question is, he provided a password 3 weeks ago, which predates you filing this enforcement, correct?
Yes, which gave me partial access, not full access.
And you never communicated to him that the issue was that there was some two-factor authentication code that needed to happen for you to get
No,
on.
that was absolutely communicated through email to your office multiple times.
Okay, well, none of those emails were produced today in court, and I'm representing to the court that we never received any emails that there was an issue with a code that needed to be provided simultaneously. Last night, he also sent you again on our family.
Maybe not. I mean, we were making this more difficult than it needs to be. You've known since February 14th that it's an issue. Why can't we just get that? I mean, I hear you're making, you have some arguments, but I can certainly modify it. Clearly, Judge Arth meant for her to have access. And if it requires two-factor authentication, or he needs to go on the website and change the credentials, and this motion for enforcement was filed on February 14th, I'm amazed that that hasn't happened up to now. I'm amazed that there hasn't been a discussion between counsel as to how we make this happen.
I agree. We received one email. He tried again last night. We didn't even know it was still an issue because we thought the password was sent weeks ago. I mean, we have no problem doing this. It's the fact that they are filing an enforcement over it, asking for attorney's fees over this. Like, they could have picked up the phone and said, hey, here's the issue. I mean, we'll do this. And he even provided her a new password again last night. He's not hiding anything on it. This is a waste of the court's time, and everyone's paying attorneys to argue about this. And my point is, he's cooperated what he was supposed to do under this order. He'll remedy it. He'll do what he needs to do. But to file a violation and enforcement over this is just absurd. It's a waste of attorney's fees.
It's a waste of attorney's fees that after February 14th, when this was filed, people didn't get together and figure out why this hadn't happened.
We didn't know it hadn't happened.
And then there's an amended hearing motion last week that lets you know that it still hadn't happened. I agree. It seems a little frivolous, but if the evidence is that it hadn't happened, then I think he's violated certainly the spirit of Judge Arth's order, and especially if there was a new password last night. She needs to get access. I'm going to order it. I mean, I think your argument and your questions prove that it hadn't happened. And I think it's incumbent on your client who has the access to make sure it gets to her.
Understood. I'll move on then.
Thank you.
So on the credit cards, Ms. Younger, you acknowledge now that you've been added or removed as an authorized user on all of the credit cards per the court's order, correct?
As of this morning.
And some as of last night as well, right?
Yes, last night and this morning.
Okay. And to clarify on the income tax liability, part of this in your email, P6, that was admitted from your attorney to my office mentions this also includes part of the CPA fees, right?
Yes.
Okay.
The CPA is specific and only deals with the California property. That is the only thing he works on. That is the only income that he works on. That's it.
All right, but you would agree with me that property expenses does not include paying a CPA.
I would not agree with you. No.
And as your attorney explained to you that my client has offered to pay the $1,700 that you're asking he be ordered to pay today.
Okay,
Well,
so,
he offered to pay it last night.
but
There
he
was
hadn't
no,
paid, here's the thing, he hadn't paid it as we sit here from last night to 4:23 in the afternoon, right?
That's
Right.
correct.
Seems like that's proven up the violation. He's offering to pay it. I sure would have felt better about it if the check or the electronic payment had been made while y'all were waiting to get heard today, or from the time I got you at lunch until 4:23.
Well, Judge, I have not received anything from opposing counsel that has said that this income tax liability is property expenses. That's the issue with this violation. Our client is happy to pay it, but I do not think this is a violation of the temporary orders, violation number 3.
Well, I think the taxes themselves, you may be right on the CPA fees, but I can clarify that. But I think the taxes, unless you want to show me that if you dispute that the taxes for California are related to the property,
No, we're
it
not
is-
saying that. It's
then
just-
it is a violation. And you've offered to pay the CPA fees too, so okay, I can clarify that. You can go on.
Okay, Miss Younger, on violation 4, the colonial mortgage. You received an email back in February, correct, from Mr. Younger trying to add you to that account?
No.
Judge, may I share my screen?
You may.
Okay, can you see now what's been marked as R7?
Yes. It does not include me.
Right, but this email was forwarded to you from Mr. Younger, correct?
No. Not on March 5th, as in like yesterday or this morning?
No, sometime around February 27th, the date this email was sent. Did you receive notice from Mr. Younger?
No, I did not.
So you had no idea he contacted the mortgage company at all?
No.
All right. Well, I believe you just testified that you did know he tried to contact the mortgage company, but it was something about he hadn't signed a letter, correct?
Yeah, I testified because you can see on March 5th, I got the email. It was this morning, actually. I got this email this morning. And last night when you emailed my counsel and you said that he had provided me access to Colonial, I was skeptical. And so I called them immediately upon seeing your email. And when I called them, they assured me that no, I do not in fact have access. And what was missing was a wet signature. So that is information that I got last night before I saw this email. I think I saw this email this morning. They had mentioned to me last night after I got your email that they did have a note on file that he had that he had written something, but that it was missing a wet signature. So that information I have from Colonial, not from Mr. Younger, and not from your office as well.
Okay. And did you and Mr. Younger also have an agreement to split a refund that you received from this auto insurance policy?
objection, relevance.
What is the relevance, Ms. Clements, about this motion for enforcement?
Well, if there's money that Mr. Younger is going to be ordered to be paid today as part of their enforcement, money that's owed on the tax liability, things like that, I think it is relevant if I have an email where Ms. Younger has agreed to split a $1,900 refund when they switched auto insurance policies, and that should be
Has
offset.
that happened already? Has the refund because the temporary orders had specific dates that he was supposed to do things, which apparently you're proving up he didn't do timely. So I don't know that that's going to do away with the violation. Has the refund from the auto insurance come through?
The refund from the auto insurance came through and was deposited into our joint business account. I had no agreement with him at all to split anything, especially considering that I was under a protective order at the time that that came through. There would have been no way for us to have an agreement about anything.
I had meant that for Miss Clements, but
Oh, I'm so sorry. I'm so sorry.
I'm sorry, guys. I was trying to pull up an email about this. Your question is if there was an agreement to split the refund from the auto policy,
my
or
question is, has the refund come through and is there an agreement? Because the alleged violations had dates in the temporary orders that things were supposed to happen. If you're talking about a future refund that or when it happened, I mean, I think you ought to focus on whether or not he did what he was supposed to do in the time he was supposed to do it.
Your Honor, and I would again object to relevance that there was no agreement. It's not in the temporary orders. I don't know what Ms. Clemens is referencing.
Well, I'm gonna let her, if the parties made an agreement, if she get that testimony, I don't know that it's gonna keep me from finding a violation. May go to how I'm gonna get it remedied, but
yes, Your Honor. Ms. Younger, so how much was deposited in the joint account from the refund for the auto insurance policy change?
I don't recall, and I don't have my bank account pulled up, but I certainly could check.
The 1640 sound accurate?
I'm going to again
yeah.
object to relevance.
I'm gonna overrule it. I mean,
Yes, it sounds accurate.
Okay. And did you have an agreement with Mr. Younger to split that refund?
I never agreed to split that refund. No, I did not agree to that.
I'll pass the witness.
Ms. Kinsler.
Absolutely. I just one question, Ms. Younger. On page 15 of the temporary orders regarding the apartments.com, the language specifically says that Mr. Younger was ordered to cooperate in transferring management of these properties to you by contacting lease runner and apartments.com to authorize you to solely carry out such tasks, right? That was the
Yes.
language of the order?
Yes.
And so Mr. Younger just giving you access to the homepage, that doesn't give you access to solely carry out the tasks that you're responsible to do for these properties, correct?
Correct.
Okay. I'll pass the witness.
I have no further questions.
Your next witness, Ms. Kinsler.
Your Honor, that's all I have for the enforcement issue. I can get to my client regarding the further temporary orders, or if we want to break up the hearings.
I want to do it all at once. I mean, I want to deal with this and then we'll go to the further temporary orders.
Yes, Your Honor.
Okay. I'm going to grant the motion for enforcement. I don't find that even the evidence that was presented shows that Mr. Younger did not accomplish what he was tasked with accomplishing by the dates he was tasked to accomplish it. The testimony was that as of last night and today, Ms. Younger was removed as an authorized user. That's number 2. Let me start with number 1. I find that by January 15th, Mr. Younger did not give Ms. Younger full violation to apartments.com. I'm going to order that the parties get on the phone together, I guess with their counsel, which is ridiculously expensive, but if that's what we have to do, we'll do. And see what exactly needs to happen. If it's that Mr. Younger has to change the credentials so that the dual authentication goes to Ms. Younger, that should be done. And I want it done no later than 6 p.m. today, Central Standard Time, if they're open. If not, or 11 a.m. tomorrow. I don't know what time zone apartments.com is in, but when we get off this Zoom, I want y'all to get on the phone together. He needs Mr. Younger, if he wants to get on the computer and change it so that she can do the dual authentication and we keep the lawyers out of it, fine with me, but I'm going to belt and suspenders it because we shouldn't be here about this. This shouldn't be this hard, and it should have happened before now. Violation 2, I find that Mr. Younger did not provide proof that he had removed Ms. Younger as an authorized user on his credit cards by February 6th. Violation 3, I find that Mr. Younger did not pay the California income taxes. It says taxes on the property. I'm going to clarify the order to say the shared expenses will include any accounting fees related solely to the rental properties. Violation 4. I find that by January 15th, Mr. Younger did not do what he needed to do to get Colonial Mortgage to let Ms. Younger have online access and discuss the mortgages. So I grant that. I'm going to order again that this evening or tomorrow, at the same times I did for violation 1, council get on the phone and see what needs to happen, and that whatever needs to happen by 5 p.m. tomorrow. If they need a wet signature, he needs to fax it to him. I'm unclear if it needs to be faxed or mailed or whatever. Whatever he needs to do, he's to provide proof of it.
By 5 p.m. tomorrow, Your Honor?
Yep. And violation 5. I need to actually, it's violation 5. Can you pull up, Ms. Kinsler? Maybe I should have petitioner's exhibit 7. And does it have the attachment showing what's due?
It's the language down here. We don't have receipts, Your Honor, if that's what you're asking.
Ms. Clements, do you dispute that those HOA fees are due?
I don't dispute, but I have no knowledge or anything about the HOA fees. The amount that would be due, I don't know.
Well, there it says on February 14th, you were given information, so I find that he's violation number 5. He didn't pay it as required. All right, and then let's go to the temporary orders, and I'll make a ruling about attorney's fees.
Thank you, Your Honor. Ms. Younger, very quickly, we are asking that multiple properties be sold. The Mulberry Street, Mr. Younger has agreed to an agreement to sell those properties.
in agreement to sell those properties, but I am nervous about selling those properties after he last night said that he had a separate property interest in those properties. That's the first that I have heard of that.
Sorry,
and-
I'm sorry. This is a court reporter. I'm so sorry. My screen froze in the middle of your answer. Can you start back up with, I'm nervous about selling those properties.
Yes,
Okay.
I'm nervous about selling those properties since Mr. Younger brought up separate property claims last night. After his counsel started contacting us, I think it was after 4. First, he said that he had separate property claims for all of the properties that I wanted to sell. And then he said that he was in agreement with selling 2 of the properties, which made me very nervous about it.
Hearsay.
Hold on.
This is hearsay within hearsay of what conversations between the attorneys about what my client has said. This was not directly a conversation between the 2 parties.
All right, sustained. You can only repeat what he's told you directly, but I mean, we can cut to the chase. I mean, if
That's what his lawyer's office told me.
Well, his lawyer's
I
office
can only go on that.
That's his actually agent.
Yeah,
Well, let me just ask you, Ms. Clements, what properties does Mr. Mr. Younger claim he has a separate property interest in?
Lakeview Cove and Anita, the marital residence.
So not Mullen or Gilmore.
No. We're in agreement with selling Mullen and Gilmore.
When is this balloon note due?
the accelerated loan.
Yes.
The accelerated loan is due in August.
Well, it sounds like we have an agreement to sell Mullen Drive and Gilmore.
Yes, Your Honor, and let me go ahead and Ms. Younger, are you requesting that you use Pete Stiles as the real estate agent?
Yes.
And is Pete Stiles the real estate agent that you and Mr. Younger have used for all of the other properties that you all have purchased and sold in Texas?
Most of them, yes.
Okay, and that's who you would like to use to sell Mullen Drive and Gilmore Street?
Yes.
And for the listing recommendations, are you asking that you all follow Pete Stiles' recommendations as well?
Yes.
And then are you requesting that those properties be sold as is?
Yes.
And how are you requesting the net proceeds be divided for those two properties?
For those two properties, I'm asking that the IRS get their capital gains first. Then money goes toward the accelerated loan on Woodruff. Then if there's anything left after that, the tax liens from unpaid property taxes on Woodruff get paid. If there's anything after that, there is $25,000 worth of electrical work that also needs to be paid off also for Woodruff.
And if for whatever reason there is enough equity to cover that accelerated loan, and is that in the amount of $253,686?
That would have been the payoff amount back in November.
I'm sorry, that the new amount is $306,347, correct?
That's correct.
Okay, and so if you all manage to pay off that balloon payment, and then the tax liens, do you believe there's going to be any money left over after that?
I do not.
Okay.
Well, let me be clear. You just said tax liens. I haven't heard about any tax liens. I heard her say she wants capital gains paid, but wouldn't there have to, that's not a lien. That would have to be calculated. So we don't even know what that is, right? But am I clear? Is it true that there's not a lien? Because those two different terms of art. You got capital gains and you have a lien. Something's been assessed, right?
Is that a question for me?
I know it's for Ms. Kinsler.
There are I'm talking two separate things. I'm talking number one, that from the net proceeds that the capital gains are set aside. Number two, that the accelerated loan is paid down. And then number three, the tax liens associated with Woodruff. I did not prove those up. Ms. Younger, what are the tax liens associated with Woodruff?
As the trustee for the Mary G. Anderson 2007 trust, I was in charge of, after October of 2021, I was in charge of the money coming in to the trust. I had saved up $75,000 knowing that there were going to be supplementary property tax bills that were coming. LA County was very backed up because of the pandemic. My aunt passed from COVID. All three of those supplementary tax bills came in September of 2024. In January of 2024, I had $75,000 saved in a bank account specifically for those bills. By September, that money had been spent by Mr. Younger.
And Ms. Younger, we are short on time. So if you can sell these two properties, number one, you want capital gains taxes set aside, you need this accelerated loan paid off. And then anything above and beyond that, are you in agreement to put it into my office's IOLTA account to figure out how the rest of those net proceeds are divided? If there's anything left, if there's a dispute over these tax liens?
I am.
Okay. I'll pass the witness.
Ms. Clements.
I don't have any questions for Ms. Younger.
Do you have any evidence you want to offer?
I would like to call my client just briefly.
All right, Mr. Younger, if you'd unmute yourself and let me swear you in.
Mr. Younger, is it your assertion that you have a separate property claim to 710 Lakeview Cove in Round Rock?
Yes, ma'am.
And is it your testimony that you used funds from the Turkey Trot residents from the cash out refi for the down payment on Lakeview Cove?
It is.
And that you owned a Turkey Trot residence prior to your marriage to Miss Younger?
Free and clear, I did. Yes, ma'am.
And you're in agreement with selling Mullen Drive and Gilmore?
I am.
And everything that Miss Younger testified to pay the accelerated loan and everything else, you're in agreement with that as well?
Yes, ma'am.
And anything left over, you're in agreement with putting in Miss Kinsler's firm's trust account to be frozen until further agreement of the parties or further order of the court?
I am.
And you've also proposed and would be in agreement with selling the Jasmine Path rental property as well?
That's correct.
That's all I have.
Well, Mr. Younger, I'm confused. You said you were in agreement to pay off the balloon payment that's due on the California property. What is everything else you're in agreement to? Because that was the question that was asked you. What else are you in agreement to do with the sales proceeds of Mullen and Gilmore?
I'm in agreement with certainly paying any liens or back taxes on that property. I'm okay with putting it in Miss Younger's attorney's trust with leftovers. I'm in agreement in selling those two houses that Miss Clements just mentioned. And then if we needed to, we can go on the Jasmine Path house as well. Every one of those houses should have between 250 and 300,000 in equity. So hopefully we're looking at 500 to 700,000. So hopefully we can get the liens or back taxes and that's all really important stuff. That's a $4 million property and the mortgage is only 300,000. So that to me is, a top priority.
All right. Well, I have everybody agrees to Mullen Drive in Gilmore. And for the first time I heard in Mr. Younger's testimony, Jasmine Pass. Ms. Kinsler, Ms. Younger, do you all want to have Jasmine Pass sold as well?
No, Your Honor.
Well, if the $306,000 loan payment could be handled by the sale of 2 properties.
That's what we're hoping that that's the case, and we'll revisit this separate property claim in Jasmine Path. There is no requested relief to sell Jasmine.
He just said he would also agree to sell Jasmine. I didn't hear him say, unless I stand to be corrected. I heard him say he would also agree to sell Jasmine Pass. I didn't hear him say there was a separate property interest in Jasmine Pass. He thinks there's one in Lakeview Cove that
Right.
results from the sale of Turkey Trot, which he claims is his separate property.
Correct. And Jasmine is a completely separate property that is about to be on the market to be rented. And once it's rented, it actually gives income to be able to support these other properties. So my client is not interested in selling that property as we sit here today. And Mr. Younger had no requested relief on file for Jasmine. And so we didn't, I guess I didn't ask my client any of those questions because
Well, that's why I stopped, because I heard one thing and then I just heard something new thrown out. So, well, again, this seems pretty easy. I'm gonna grant the additional temporary orders, and we're gonna list. Well, Mr. Younger, do you agree that Pete Stiles should be the listing agent?
I'm okay with that, Your Honor. He's helped us for a lot of years.
All right. Then the order of the court is that Mullen Drive and Gilmore Street should be listed as soon as possible. And that Pete Stiles would be the listing agent. I want this typical language that says, you follow his recommendations about anything you need to do to get the best offer. I have no idea if saying sell as is makes any sense. What if it says, if you put $5,000 in it, we can get you an extra 30. That would not seem to be a good economic decision to me. So I'm only going to order that Pete Stiles be the listing agent. I want him listed as soon as possible, but no later than April 1st. From the sale, we'll pay off the balloon payment due on what's the name of the property in California? Woodruff.
Woodruff, WOODRUFF.
We're going to pay off the balloon payment due from Woodruff. And if one property sells before the other, if it's possible to go ahead and make a partial payment on the balloon, take the proceeds from that sale and pay that down. Because it's possible that both of them might not sell in time, right? So if Mullen sells and you get 200, take that 200 and pay toward the 306 that's owed. If they both sell and you can also pay any capital gains that have been calculated. Again, I don't think anybody knows what those are, but if the CPAs agree on the capital gains, and everything else will be escrowed in Ms. Kinsler's IOLTA account and not spent unless there's an agreement of the parties. All right. Ms. Kinsler, do you have further evidence?
I have attorney's fees, Your Honor.
All right.
For a second. I have been a family law attorney for over 15 years. I'm currently licensed in the state of Texas and the state of Illinois. I am board certified. I've been board certified since 2020. My current hourly rate is $500 an hour. However, I am helping on this case at my associate's rate, Ariel Roswell's rate, since she is out on maternity leave. The rates that we're providing in this case are reasonable and necessary.
What is Roswell's rate?
Absolutely, Your Honor. Ms. Roswell's rate in this case is $375 an hour.
Thank you.
And we did, I'm also currently in good standing. I'm a member of the Texas Foundation. I am a partner with my current firm. And had to give up other cases in order to handle Miss Younger's case. And so my office did prepare a petitioner's exhibit 3, P13. Sorry, Your Honor. My office created a attorney's fees and expense summary, and we separated it out by the motion to compel, with the fees and expenses equaling $4,180.65, which was the work in progress through March 3rd. And then I did an estimated cost through trial. So yesterday and today of having to put on the motion to compel. Same for the motion for enforcement. We did a work in progress through March 3rd. The total amount for the motion for enforcement is $2,941.95. Attached to petitioner's exhibit 13 are our unredacted attorney's fees statements, in which we've gone through and highlighted all of the work that was done specifically. I say that and it's not showing up on this. There should be highlights showing up on this of the work that we did for the motion to compel and the motion for enforcement, Your Honor. Give me 1 second, because when I'm sharing, I'm not seeing this. We had for P13, we had gone through and highlighted all of the separated out when there was enforcement versus compel, which is how we came up with these specific fee numbers and highlighted them. For whatever reason, P13 is not showing up my highlighted statements. If you could give me 1 second, Your Honor, or I can. Sarah, do you mind forwarding me the highlighted statements?
Yes. I wonder if it's just due to screen share, because when I pull up the exhibit, it's highlighted.
Okay.
Do you want me to try to screen share?
Maybe.
Okay.
Ms. Clemens, when you pull it up in the box, do you see highlights for that correspond with the motion to compel and the motion for enforcement?
I don't have your box open. I just have our exhibits. Let's see. But you can go ahead, Ms. Kinsler. I'll work on getting this.
Okay. Your Honor, I'd like to offer
It shows up when I pull up box, it shows up with highlights.
okay, so just the screen share is not showing up for me to be able to point it out. But Your Honor, I'd like to offer petitioner's exhibit 13 as my attorney's fees summary, and then the unredacted statement showing the work done on Ms. Younger's compel and the enforcement.
Clements, do you have any objection to P13?
No objection.
P13 is admitted.
In also the enforcement matter, we were asking that Mr. Younger be fined $500 per violation as well. And for the compel, I believe we needed just a confirmation of when the documents would need to be provided. I think we accidentally skipped over that part. And I'll pass me.
Ms. Clements, you can cross-examine Ms. Kinsler, but you could also let me know how much time you need to provide all the documents you said you would provide.
You're talking about everything within the compel, those documents?
Yes, ma'am.
I mean, I would say 2 weeks at least, because Mr. Younger is having difficulty, gathering everything. So can we do by March 21st?
Y'all don't have anything else set immediately? All right.
I'm
By
fine with
March,
that, Your Honor.
by March 21st. All right, do you have any cross-examination for Ms. Kinsler?
I do, and I'm having trouble getting on Box. Colleen, do you mind just pulling up your cover page for me?
Absolutely.
So in the Compel itself, your motion, I believe you were asking for $1,500 in attorney's fees, and now you're saying you've spent these additional amounts, and now you're requesting $4,180 just for the motion to compel.
Yes, you guys supplemented late last night, and so we went in and completely tried to supplement, go through and update our order to compel so that the court had the most live information. So when we filed the motion to compel, Mr. Younger had not supplemented anything yet.
And do you know how many hours went into drafting the motion to compel?
I'm going to try to pull this up in a separate document. If you could give me 1 second.
You would agree, though, that your time, the way you're trying to segregate it out, I see what you're trying to do, but for the work that you spent yesterday is for combined for the temporary orders, the compel, and the enforcement.
Correct.
And those aren't segregated out between those 3 different matters in your attorney's fees exhibit.
Because we're not asking for fees for the further temporary orders. So the projection through trial of the 1150 is obviously the work for both myself and Miss Martin. And so the fees that say projected through trial for the compel, that's 3 hours of preparing all day yesterday and talking today regarding the compel and then putting on the hearing itself. So the 1,150 is 3.06 of my time only. Same thing with the motion for enforcement. The projected through trial of the 1525, if you divide that by 375, that's 4 hours for the enforcement between my billing yesterday and today. So prepping my client, communicating with you, waiting to get set for this hearing and having this hearing. So 3 hours yesterday for all that prep and the showing up for this compel hearing, 4 hours for the enforcement yesterday, which you testified a lot of the stuff came in last night, this morning of us still trying to work it out. And then me putting on this evidence. And so I feel like 7 hours for the motion to compel and the motion for enforcement alone is not unreasonable for the past 2 days. And that doesn't consider the motion for further temporary orders, as was evidenced by even today's hearing alone, that hearing only took 30 minutes compared to the rest of this, which we have been in front of the court since 11:30 or 2. You and I tried to communicate regarding the compelled R3 order during lunch. So I feel like this estimate is actually an underestimate, if anything.
Okay, and does your firm do block billing? I couldn't see, and I don't have it in front of me.
I don't know what you mean.
I mean, for example, does a time entry include at the same work on the enforcement, work on the temporary orders, work on a waste claim I saw on there, all in one entry? Or does it say this is just for work that you did on just the compel, and this is just
Right.
that you did just on the enforcement in each entry?
Sure. So we do try to separate it out. We only do 1 entry per day, right? But then within the entry itself, we do try to be specific if it's working on a specific document. We do try to separate it out that way.
Okay. I have no further questions.
Thank you.
But Judge, can I just say one thing about the attorney's fees then?
Yeah, you can.
If she does do block billing, I'm just saying, I think that there's double dipping. if she just said that one entry includes work for one entry per day on the case, that they're part of those fees are going to include work that was not specific just to the enforcement or just specific to the compel.
Well, I pulled them up. I understand what you're saying.
Okay.
Okay. I'm going to award attorney's fees because this shouldn't have happened, especially since so much of it was agreed upon. I really don't understand how you can get motions that far in advance and amended motions and somebody didn't pick up the phone and say, why isn't this taken care of? This shouldn't have happened. Mr. Younger, you should have figured this out. I think this is, and the fact that I'm glad you got her taken off as an authorized user last night or today, but why you waited that long and caused her to expend attorney's fees is beyond me. So I am going to tag you. I'm going, because the motion to compel specifically says $1,500, I'm going to award $1,500 for the motion to compel. However, for the enforcement, I'm going to award the requested $2,941 for the enforcement, as well as $2,000 in penalties as requested. So for the enforcement, it's a total of $49.41.95. I wasn't at your temporary orders. I can read the file, I can see the notes and realize that there's a lot going on. I appreciate the fact that y'all agreed to sell these two houses, but again, why we needed to have a hearing about that is kind of beyond me. How quickly can, Ms. Kinsler, I want you to draft these orders. I've been setting a lot of things for a motion to enter. Ms. Chambers is going to tell me after spring break on the 26th. At 1, are y'all both available for a Zoom at 1:30 on the 26th? If we need a hearing to enter orders.
I'm in Williamson County that way, Your Honor. Williamson County that day.
Okay.
I am available the 28th that week.
All right. Oof. I have something I have to do. Let's do the 28th at 9 a.m. Ms. Chambers, I hope you're helping me here. Do y'all want to do it Zoom or in person?
I believe, Ms. Clemens, you'd prefer Zoom, right?
Yes.
Okay. This is your only open court notice. I want you then, Ms. Kinsler, to 3/28. Yeah, Ms. Chambers. I want you to have these orders by the 14th to Ms. Clements. Ms. Clements, you need to respond the next week's settlement week. I don't know if you're going to be gone. I can give you till the 24th, since you might be gone for spring break.
Okay, that
And then
works.
if y'all don't have it worked out by the 28th, you'll have a motion to enter. If you get the orders done and agreed as to form, you don't need to show up for the motion to enter. Okay.
Thank you, Your Honor.
Anything further?
That's all I have.
All right. Thank you all very much.
Thank you.
All right. You may be excused. Thanks.